Representing the liquidators, barrister Matthew Morrison KC opened their case, alleging that NatWest had failed to take appropriate steps to prevent what he described as a colossal fraud. He told Judge John Restano that the case is not about whether transactions were authorised, but whether NatWest had failed to identify a clear pattern of suspicious activity involving large transfers to high-risk jurisdictions like Ghana and Guinea. These, he argued, were obvious red flags that should have triggered further scrutiny. Mr. Morrison pointed out that the bank itself had become concerned when it raised a suspicious activity report in 2015. However, he claimed the red flags were there as soon as the account for Kijani Resources Limited was opened in 2012 and should have been picked up by any reasonable banker. The court heard that the original application to open the account for KRL was rejected in 2011 because of links to Tanzania, which was deemed high risk, but that a second application citing no risk factors was accepted by the bank the following year. Within a month of opening, the account had transferred £12 million to a subsidiary in Ghana, with total payments to Ghana and Guinea reaching $25 million in the first year. The liquidators argue that the bank's relationship manager should have recognised this pattern and reclassified the account as high risk, which would have triggered enhanced security. Instead, they claim he allowed the account to continue operating, eventually under a new name, Kijani Limited, without applying the high-risk classification. Despite discussions about closing the account, it remained active, and other staff also failed to act on what the liquidators describe as clear signs of fraud, until a SAR was finally filed in 2015. Mr. Morrison told the court that this was not a case based on hindsight, but one in which the bank had knowledge of the fraud as it was happening. Speaking on behalf of NatWest, barrister Nicholas Medcroft KC urged the court to view the case from the perspective of bank staff at the time and not with the benefit of hindsight, which can make past events seem more obvious than they actually were. Mr. Medcroft addressed what he called 10 big picture points and highlighted the following. Firstly, the bank's obligation is to carry out its clients' instructions. Secondly, he asked, did the bank have reasonable grounds to believe they were unauthorised to make the payments? If not, then it had no general duty to prevent the fraud. Thirdly, the bank is not required to act as an investigator or scrutinise accounts in minute detail. Fourth, he pointed out that regulatory obligations are enforced by regulators and not through private claims. And fifth, he said the claimant companies, Kijani and Ratio, were fraudulent from inception, operating a sophisticated Ponzi scheme. But bank staff, he said, were also misled with false documents and assurances. He referred to the company's directors as confidence tricksters and argued that NatWest employees had been deceived just like everyone else. Mr. Medcroft will continue his opening argument tomorrow morning. The trial is set to last 4 weeks.